Your Humanities Half Hour is brought to you by the Northern Marianas Humanities Council.
Welcome to your Humanities Half Hour. I'm Catherine Perry, and today we are talking Insular Cases, and we are joined by former CNMI Supreme Court Chief Justice Jose S. Dela Cruz via Zoom. Justice, welcome back to the show.
Well, thank you. It's a pleasure to be on the show. I always enjoyed trying to give my 5 cents worth on some of the issues that are facing the Commonwealth and I guess the other territories for that matter on today's show.
Well, I think it's worth a little bit more than 5 cents. This topic of the insular cases, and I'll just start it off briefly and then really allow you the opportunity to help us understand it. But for those of us that may not be familiar, it's a series of cases for the U.S. to govern the U.S. territories, and it basically gives Congress the constitutional right under these cases to deny some rights to U.S. citizens living in the territories, including the CNMI, Guam, Puerto Rico, American Samoa, U.S. Virgin Islands. Justice, did I get that right to start us off?
Yeah. You basically have it right. The Insular Cases really resulted from a case that originated in Puerto Rico in 1901. And 1901 is over about 120 years ago. And it's as a result of the Spanish-American War, and the Spanish-American War is really over Cuba. Theodore Roosevelt knows the Rough Riders and all of that. And then in the end, when they settled the war and the treaty was entered into between Spain and the United States, they came up with these 3 spoils of the war. And one of them was Puerto Rico. Puerto Rico was turned over to the United States as one of the spoils. And the other one, of course, is the Philippines. A lot of us passed by that so many times, but the Philippines was much larger than Puerto Rico. And of course, the third one is Guam. Of all the Mariana Islands, the United States didn't want the other islands, and they only needed it basically for as a way station to be able to stop by, get water, get coconut milk, and get food and all that, and then proceed to the Philippines. You know what I mean? And that was in 1898. And there's a fine distinction between territories and commonwealths. The use of terms are not really the key thing. It's how they're used. In the case of the Northern Marianas, we use the word Commonwealth because to distinguish it, I guess, from the other territories that were acquired by conquest.
Versus us, where we voted to become a Commonwealth.
Yeah. And it's a result of the United Nations Trusteeship Agreement. But going back to the Spanish-American War and the Insular Cases, these are cases. And what do we mean when we say cases? They're cases that were filed in court. And in this case, in the case of Puerto Rico, for example, it has to do with duty. The assessment of duty on goods imported from Puerto Rico, in this case to the Port of New York. And there was a question, if they are part of the United States, then they would not be subject to tariff, right? Because you're part of the country. But in this case, it went up to the United States Supreme Court. It's the first time in the history of the United States that had to deal with a territory that is not within the continental United States. You know what I mean? Mm-hmm. Most of the territories are, like the Northwest Territory, the Louisiana Purchase in 1803 from France, when they purchased that huge swath of land all the way from Mississippi, at the end of the Mississippi River down here in New Orleans, all the way up to Canada.
That's what's so interesting about the Insular Cases is, as you said, there were other territories that came
Yeah, I
before
mean, they
us,
don't care
but
whether it comes
they
in
weren't. Yeah, it wasn't
by
until
stagecoach or
yeah, it wasn't until they started dealing with territories outside of the continental U.S. where they said, okay, we're going to treat these territories different. We're going to treat the people in these territories different, right?
yeah, because they are from a different place outside the geographical location of the states that were then in existence. There were no at that time. There was not all the 50 states, right?
Correct.
And the United States. So you have to think about this and think also of the drafting of the United States Constitution in 1787. By the time it was adopted in 1789, there were 13 regional colonies, and those were the original 13 states, and none of them were, an island, So in 1898, it was the first time they've acquired a territory outside the continental United States. And they were faced with this question of whether to impose tariff from goods that are imported from Peru. I don't know whether it was agricultural produce and all of that. And it went up to the United States Supreme Court. And then the justices of the United States Supreme Court at that time were the same justices that decided the so infamous Plessy versus Ferguson case. The separate but equal facilities clause, separate but equal schools, for example, it's discrimination at its finest, I guess, is the best way to put it. And it took the United States Supreme Court that length of time, from the time Plessy was decided in the late 1800s until it was decided in 1954 by the United States Supreme Court with what's his name, Earl Warren as the Chief Justice of that court at that time. They overruled. Talk about overruling a prejudicial type of case, and the continuation of the Insular Cases. And one of the things that I noted in some of my writings about the Insular Cases that they were not sure. The justices do not really have an idea what the people of the islands are like. They have some ideas, but and that they're primitive, savages, in one of my conversations with Glenn Manglonia and Marianas group, I said, well, they don't wear shoes. They wear, so they're primitive. And what do we do?
That's what they thought of us. Yeah.
Are we going to make them citizens and all that? Remember Guam, when it was acquired in 1898, it took them 52 years until 1950 when the Guam Organic Act was passed. So Guam was not even a territory between 1898 and using that term, between 1898 until 1950, because there was no civil government of Guam. There was no Organic Act, as people would put it, by Congress. The organs of government, the so-called Organic Act of Guam, was not enacted until 1950. And so I guess Guam was just a mere possession, piece of property that belongs to the United States. And the only thing they have on Guam was a group of military contingent. And that's why you have names in Guam like Underwood, for example, Johnston. The Philippines was the main territory with, I don't know, at that time, maybe 60 million people in the Philippines. So they decided at the end of the World War II in 1946, I think, to just allow the Philippines to become an independent country. And so Guam, though, in 1950, was authorized to have a civilian government. But even the civilian government was headed by an appointed governor. It wasn't a thing until 1970s that Guam was able to vote for their own governor.
So how are the Insular Cases affecting us today? And especially the Commonwealth maybe is a little bit different from some of the other territories.
When they were negotiating, and that's a question that I'm thinking of asking some people that were part of the covenant negotiations, for example. And I don't know, it may be in the book that was published by Howard Willens and Deanne Seymour, his wife. But I like to ask Ed Pangilinan, for example, how about some of these questions, that we were not conquered we were not a spoil of war. The Northern Marianas, when it negotiated the covenant with the United States, it negotiated it because for a long time, as I mentioned in my book, the people of the Northern Marianas had been advocating to join the United States, either directly or by integration with Guam. But when the people of Guam, I think 1968, had some kind of referendum as to whether they want to join the Northern Marianas, they said, no, we don't want to join with the Northern Marianas. We negotiated the covenant as part of our right to political self-determination under the trusteeship agreement. But the way it was approached was not through some idea that Northern Marianas would become a territory, quote unquote, of the United States, would become a Commonwealth, whatever that means. And that's why in my first book, I mentioned that, you know, the word Commonwealth is a word that means what the terms of the covenant says. That's what and you could call it whatever you want to call it.
Okay, so it's defined by the covenant. Yeah.
Right. It's part of our expression to political self-determination. It was negotiated as it's an entity joining the United States under this agreement. And it's nothing envisioned in the United States Constitution. It's a unique first time a group of islands joined the United States through an agreement, a formal agreement. Nobody has ever done that. We're the only ones that did that. We were kind of unique in that respect. And so this question of whether, you know, in the Insular Cases ruled that the territories are not a part of the United States. And that's why it ended up imposing tariffs on those goods that we were talking about earlier from Puerto Rico. They had to pay taxes. Whenever you ship goods from Puerto Rico to the United States back then, you have to pay duty.
We're talking about the Insular Cases today. Our guest today is former CNMI Supreme Court Chief Justice Jose S. Dela Cruz, and we'll be back after this break.
Northern Marianas Humanities Council bula guinahanya puri historian Marianas zan kultura. Sinyon soda esisihanan formasyon gi zon mami website nmhcouncil.org pat bisita gi YouTube pat Facebook. Guahaloque diferentes clases leblu na sinya unfan. Northern Marianas Humanities Council has uzura todo I experiencia tautau.
Welcome back to your Humanities Half Hour. We're talking about insular cases today. Justice, I understand that, for example, here in the CNMI, we can get supplemental security income benefits, but that's not a benefit that's extended to all the other territories. So what are we talking about here?
Yeah, okay. A lot of the federal programs apply to the territories. The Congress, in its wisdom or what lack of wisdom, sometimes does things that are unusual. In the case of the supplemental security income, the law basically states that it's basically for people in the 50 states. It's not for, it doesn't apply in Puerto Rico. So the Vallejo Madero case, it's a guy, a Puerto Rican, moved to Illinois, stayed in Illinois for, I don't know, 10, 20 years, then decided to move back to Puerto Rico after 20 years. When he moved back to Puerto Rico, the SSI people said you can't be receiving any more SSI benefits. Whereas in Illinois, it's one of the 50 states. He was able to receive supplemental security income. Why? He's a U.S. citizen, both in Puerto Rico and in Illinois, but Puerto Rico is not a state, and it's only for the states. What about the Northern Marianas? Well, the Northern Marianas negotiated it in the covenant. I was able to get it. And they, you know, Ambassador Franklin Hayden Williams said, yeah, you can have it. What else do you want? What else do you want?
Well,
And they forgot,
go ahead.
that's what they forgot. They forgot about the exclusive economic zone in the waters. You know, you got to remember Puerto Rico's they've been waiting for Puerto Rico to decide whether it wants to be a state or not. The only problem with Puerto Rico is they have so much island politics in Puerto Rico too. They don't know what they want, whether they want to. Some of them say, well, let's keep being a Commonwealth. Now, the Commonwealth of Puerto Rico is different from the Commonwealth of the Northern Marianas. Puerto Rico is a territory. Puerto Rico is a territory, but they call it a Commonwealth. I don't know why. We are a Commonwealth. We're the only ones that negotiated our entry into the United States American political family. Although some people would argue that, you know, we are still not part of the United States. So when did they stop imposing duties on goods coming in from the territories and the Commonwealths? And sometime the United States government passed regulations and the Congress allowed the General Head Note 3A of the duties and customs regulations of the United States exempted the territories and commonwealths. And that's the reason why. And that's the reason why we have that textile industry. The garment companies was able to capitalize on that. And they say, well, there's an island out in the Pacific called the Northern Marianas, and they are exempted. And they say, well, why don't we go there? And so they got a hold on some of the lawyers on the island, and they were able to literally transplant a part of their operation in China and Korea over to the Northern Marianas.
Let's talk about what's happening currently as we prepare to wrap up with the Fitisemanu. I hope I said that correctly. Versus United
I don't know how to
States
pronounce
case.
that. I was pronouncing it Fitisemanu.
Our apologies to the gentleman, but what is the importance of this case?
This has to do with citizenship, you know. And let me mention this because this is very important. To the extent that the territories are under the bailiwick of the United States Congress, you wonder sometimes what the US Supreme Court is doing with some of these cases. Because the reason why the Supreme Court ruled in 1901 in the Insular Cases with respect to duties is because it was brought to the United States Supreme Court. And then they were faced with the question of what do we do with this group of islands? And they came up with this notion of, you know, the Constitution not applying to the territories unless they are destined for statehood. Interestingly, in 1898, the territory of Hawaii was annexed by some people from Hawaii, mostly, I hate to say this, whites, I think, that went to Washington, D.C. and persuaded the Congress to annex Hawaii. Then they put the Queen in jail, in prison over there in Honolulu. That's a big thing. And they annexed it, and it became a part. The United States Congress annexed it and became an incorporated territory, meaning that the U.S. Constitution would apply to the territory of Hawaii, unlike Puerto Rico, where it doesn't apply automatically. And so that is the reason when you asked earlier about which provisions of the United States Constitution apply to the Northern Marianas. Well, they spelled it out. In chapter 5 of my second book on the Northern Marianas, I listed all of those provisions. One of them that did not apply to the Northern Marianas is the territorial clause of the United States Constitution, because it was not in that list. If you look at that, I mentioned that territorial clause was not included as one of the provisions of the Constitution that applies to the Northern Marianas, but it applies to all the other territories, I guess. That's a big distinction, I think. So in terms of the law, in terms of practice, I don't know whether it makes much of a difference. We still are viewed by the United States Congress as if we are a territory, like the rest. When they're doing any overview about the Commonwealth and the territories, they put us in the same basket.
So do you think this case of Fitisemanu, where the gentleman was born in American Samoa but not given U.S. citizenship because
they're
of
arguing.
the agreement, do you think this is going to have a significant impact on the insular cases? Or what do you see as the future for the insular cases?
Basically, I think the argument in the Fitisemanu case is this, that if you are a U.S. territory, then all the residents of that territory should be United States citizens, just like the rest of the other territories are. You know what I mean? Over 3 million people in Puerto Rico are U.S. citizens. The people on Guam are U.S. citizens. The Northern Marianas are U.S. citizens. The United States doesn't acquire a territory or Commonwealth unless its people would become United States citizens. But you got to remember, back then in the 1800s, I mean, after the Insular Cases came out, they did not become automatically U.S. citizens. It was not until 1950, like I said earlier, about Guam. Remember Guam? Guam, the people did not become U.S. citizens. And so people that were in Saipan, for example, that moved to Guam after the war and before 1950 automatically became United States citizens. And the Guamanians that were in Saipan did not become U.S. citizens, I guess. Mm-hmm. so that's the distinction. But they are arguing that to the extent that American Samoa is a U.S. territory, that the people of American Samoa should all be United States citizens, and that's basically the right. But for me, it's one of the weaknesses. I mean, it's really up to the people of American Samoa, because the chiefs of American Samoa back in the 1930s, I think, when American Samoa decided for whatever reason to join the United States, but to maintain their customs and cultures and all of that. And they still have in their legislature the House of, I don't know, Chiefs, I think. And they did not want to become U.S. citizens. Somehow, it reminds me of the late Larry Hillblom, you know what I mean? Arguing that, we should not seek a U.S. delegate to the United States Congress, because that would make us seem like we are under the United States and not an equal partner. Well, we're not exactly an equal partner with the United States. He viewed the covenant as if it were a treaty. Now, a treaty is between two sovereign nations. One of the things about the covenant is that on the very first section of the covenant, the United States the Northern Marianas joined the United States as a part of the American political family, and it's under its sovereignty. And in terms of the supremacy of laws, for example, the hierarchy, which one comes first, which one is the chief law? The United States Constitution is. The interesting part of the United States Constitution, though, with respect to the Northern Marianas, is that not all of it applies to the Northern Marianas, yet it is the supreme law of the Northern Marianas, together with the covenant. I've argued that the Insular Cases is an anachronism in this day and age, maybe back in the 1800s, when, it's sort of like how the law develops. It develops in increments, you know what I mean? It just doesn't change overnight. And that's why, this thing about the Supreme Court, whenever it decides cases, it takes them a while to figure out what to do. And so this notion of overruling precedents, unless it's very clear that it should be overruled. In this case, I think it should be, because the Insular Cases is really a discriminatory law. At some point, I think the people of American Samoa have to decide for themselves what they want. Do they want to keep on being a U.S. national? All they have to do, the people of American Samoa, and I don't mean this in any sense as being disrespectful, this is their decision to make. if they want to be U.S. national, but between being U.S. national and being a United States citizen, it's sort of like the moon and the sun, the sun shining on you or the moon. It doesn't shine that much. And being a U.S. national, you go to the States, those people are wondering why they can't work for the federal government, for example. You have to be a U.S. citizen. You know what I mean? But the insular cases themselves have already decided. And that's the reason why we have the land alienation clause that is allowed under the Northern Marianas Covenant. It's because of those insular cases. They said land is not a fundamental right in the territories, but it is in the 50 states. And having the one man, one vote rule in the legislature, I don't know how they're going to do that in Guam with only one house. You know what I mean? But they say, well, it doesn't matter whether it's based on population or not. And then the third one, of course, is the right to a jury trial. That's the third deviation from U.S. constitutional norms. The local legislature may decide in what cases, how serious the case should be before you are entitled to be tried before a jury.
If the insular cases were overturned, would Article 12 in the CNMI still apply, land alienation?
Somebody would try to argue that. But I think there are a lot of arguments that could be made that, that would provide for that continuation of that land alienation clause. Okay. I haven't really thought about that because Guam doesn't have a land alienation clause, but I guess it could if it wants to. Sure. This Filismano case, if I may, although it's something I think that should be accorded to every American Samoan citizen, that they should be accorded that right to become United States citizens. You got to remember also in the Northern Marianas, they have this provision in there that in the covenant that says it's up to you to decide whether you want to be a U.S. citizen or a U.S. national. I don't know whose idea was that to put a U.S. national in there, a choice, so that it doesn't seem like they're forcing you to become United States citizen, but it's in there. It's in our covenant. The choice between becoming a U.S. national. But why would you choose to become a U.S. national when you cannot even vote? But the argument could be made that, you're a U.S. citizen, but you still cannot vote for the United States president. And then you could also argue, on the other hand, that used to be the case with Washington, D.C. It used to be that because Washington, D.C. is not a part of any of the 50 states, the U.S. citizens that live in Washington, D.C. cannot vote for the United States president. I don't know if you're familiar with that. You probably are. You have read the book already. But they used to not be able to vote for the United States president until the United States Constitution was amended. So the U.S. Constitution has to be amended. And my argument basically is this: a lot of these things require an amendment to the United States Constitution. So that, for example, we could be represented in the United States Congress not with a non-voting delegate, but with a member of Congress from the territories. That could only be done by an amendment to the United States Constitution.
Our guest today has been former CNMI Supreme Court Chief Justice Jose S. Dela Cruz, talking about the insular cases. This has been your Humanities Half Hour. I'm Catherine Perry.
Your Humanities Half Hour is a production of the Northern Marianas Humanities Council, funded in part by the National Endowment for the Humanities. Any views, findings, or recommendations expressed in this program are those of the participants and do not necessarily represent those of the National Endowment for the Humanities or the Northern Marianas Humanities Council.